It's difficult to establish a will's invalid. There is a high bar to prove that. It's on you, if you're alleging it's invalid, to prove it's invalid. The reason there's such a high bar is because the main witness is dead. They can't give their version of events. So you've got to be very clear with your evidence as to why you're saying the will is invalid if you're going to succeed. One of the first things that we would do is we would obtain the will file from the will writer, because let's say, for example, you were expecting to receive quite a lot of money because you're a child of the deceased, but for some reason the deceased changed their mind and didn't want to give you anything because you'd fallen out or something had happened. You would expect to see a note in the will writer's file as to why they weren't giving you anything, why you were being excluded. And that's quite often, evidence that's accepted by a judge. Well, the testator didn't want to. So testamentary freedom, allows you to do whatever you want. We don't have forced heirship in this country, where in other countries you have to leave something to your children. Here we don't, so it's the testator's choice. So we would obtain the will file. Again, that might flush things out quite quickly one way or another as to whether there was a valid claim. If there's no will file and it's a homemade will, in other words, somebody has drafted something on, and quite literally could be the back of a fag packet, if that has been witnessed and all the formalities of the Wills Act have been complied with, there's no reason why that's not a valid will. There would be more suspicion potentially there if, say, it turned out I had a case once where the main beneficiary's wife had handwritten the will out for the testator, which looked a little bit suspicious. And if the court suspicion is arisen, if it's aroused by that kind of situation where you think, well, actually they're not completely independent, there might be something going on, then it would be more easy to challenge that kind of will. But if it's a will that's been professionally drafted and there's good notes, a good attendance note as to what the deceased wanted to happen and why they wanted to leave people out, it's going to be very difficult to challenge that.